This was the risk of material adverse deviation webinar. So we're going to start off with an antitrust statement, just in case people from various insurance companies, we don't want them to run afoul of any laws. So certain attendees here are or may be considered competitors in the insurance marketplace. By continuing to participate in this webinar, you acknowledge and agree to avoid any conduct that might violate or create the appearance of a violation or any applicable antitrust laws. This presentation was designed for informational purposes and to provide a forum for the expression of various points of view on the topic of this presentation. This event may not be used as a means for competing companies to reach any understanding or agreement, whether expressed or implied, that restricts competition or in any way impairs the ability of companies to exercise independent business judgment regarding matters affecting competition. Please refrain from discussing any competitively sensitive topics, including but not limited to specific present or future prices of products or services, underwriting practices, present or future sales terms and conditions, current or future business strategies, policies, intentions, or marketing plans, costs or profits with respect to any of these items, or any boycott or refusal to deal with any customer, competitor, or supplier. It is the responsibility of all attendees to be aware of antitrust regulations and antitrust compliance policies and to prevent any type of discussion that violates the same. First presenter is Joe Petrelli, who is the president and co-founder of Demotech, a ratings firm that's heavily involved in the Florida market. He also has over 30 years of actuarial experience, giving him an expertise in material adverse deviations, which is the focus of the webinar. Demotech has a lot of experience in the Florida marketplace, looking at reinsurance and the business practices involved there, and he'll be applying that knowledge here for you today. We also have Guy Fraker, the principal of Create Futures. Guy has dedicated the most recent 15 of his 35 years of his career to world-class innovation practices, as well as the events, markets, and technologies, risk management from rating and recovery towards prediction and prevention. He has experience as a CIO and brings thought leadership to the marketplace and provides insight to a wide variety of companies and governments. Wesley Todd, the co-founder and CEO of CaseGlide. Wesley has spent his entire career helping claims organizations and law firms manage litigation. He leads their strategic vision. CaseGlide is a claims litigation management software that drives efficiency, delivers insight, and reduces costs. And our final panelist will be Lisa Miller, who's the former Florida Deputy Insurance Commissioner, and her firm, based in Florida, provides government consulting and advocacy in Florida's legislative and executive branches, business development, and public relations, with a percentage of her time devoted to a pro bono consumer advocacy practice. With that, I will turn it over to Joe.
Thank you, Paul. Part of what we want to do today is we want to discuss a section of the Statement of Actuarial Opinion. The National Association of Insurance Commissioners and the Departments of Insurance put the Statement of Actuarial Opinion for property and casualty insurance companies in place around 1989. And so people look at the Statement of Actuarial Opinion. It's an annual report produced at December 31st, and it's an actuary's opinion related to the loss and loss adjustment expenses, both gross and net, that have been booked by the companies, the insurance companies. In 2001, the Statement of Actuarial Opinion was amended, and it includes a section that's called the risk of material adverse deviation. And we'll be discussing this in detail as we go through today's discussion. However, the risk of material adverse deviation is sort of a two-part discussion. The first part is the actuary picks his or her materiality standard in dollars. 10 million, 20 million, 30% of surplus, 20% of reserves, whatever that dollar amount might be. And then the actuary must discuss major factors, combinations of factors, or particular conditions underlying the risks and uncertainties of the actuary's projection that the actuary considers relevant. And what we want to do today is looking at the Florida property insurance marketplace. we're going to get a variety of discussion topics related to those particular conditions underlying the risks and uncertainties, and basically to evaluate what might be or what might not be the risk of material adverse deviation discussion in any particular actuary's or particular company's statement of actuarial opinion. What you'll be hearing from us today are our opinions only, discussion topic, nothing specific. And I'd like to start out, we're going to have a presentation of some experts on the state of Florida. And Lisa, you spent most of your working career getting the pulse of elected officials and appointed administrators, producers, and consumers. Could you tell us a little bit about the excerpts that Paul's going to be playing and what we're going to be hearing?
Thank you for that, Joe, and it is indeed a privilege to serve with these distinguished guests. But more importantly, I want to thank the audience for taking your time today to listen and learn. I know we all know what your pace of business is, and so for someone to stop long enough to take the time to listen and learn means a great deal to all of us. Hats off to you. I want to set the stage because what we have done is taken public testimony and brought it to you. So many of you cannot come to Tallahassee or have ambassadors or others that do. And I live in Tallahassee and spend my days following what regulators say and listening to legislators and educating those who, frankly, there's just a handful of legislators, a couple, 3, 4, that really understand property insurance. I laugh jokingly and I tell Joe and the others on this call, people see me coming and they either come toward me to talk about property insurance or they run the other way. And a lot of it is because it's scary. It's like buying fine wine, if you'd like to think of it that way. It's intimidating. So what I try to do, working with great folks, at the fair and the Federal Association of Insurance Reform and Guy and Wesley and others, is to try to take the mystique out of property insurance. And then I attend many, many hearings legislatively and the regulatory scheme, the cabinet meetings, and you'd be surprised what you hear. It's quite fascinating to watch and see the story unfold, if you will. So we're bringing the story to you. So there'll be a series of 4 segments, about 10 minutes. So grab a Coca-Cola or a cup of water. And I want you to listen, as we do, to what these very distinguished state leaders are telling you. The first up is Barry Gilway. And for those of you that don't know Barry Gilway, he's the leader of Citizens Property Insurance Corporation. Barry's been in this business over 50 years. And when I don't know something about insurance, I call Barry because he is the dean, in my humble opinion, of sound public policy, particularly when it comes to residual markets, the markets of last resort. And he's been our steadfast voice, if you will. Sometimes he can say things that we can't as private companies. And he's all about educating those who will listen about the state of the market and what needs to be done for good public policy in Florida. Right after Barry Gilway will be David Altmeyer. Many of you know Insurance Commissioner Altmeyer working as hard as he can to make the market competitive and robust for consumers, reviewing rate filings, making sure there's a balance between rate increases and company solvency. David is a consummate insurance professional and practitioner, and we are privileged to have him as our insurance commissioner. Following Commissioner Altmeyer will be Tasha Carter. Tasha Carter is Florida's insurance consumer advocate. And whenever you see a storm and if you're in the field, you see Tasha. She is representing the voice and the face of consumers. So much so that we see her much more frequently now than we ever have, because as you know, rates are going up. Consumers are taken advantage of by those folks that knock on their doors and lock these consumers into contracts they wish they hadn't. All the tricks that you hear, Tasha is out fighting the fight and the voice and the face of consumers. My hat's off to her. I have tremendous respect. Finally, the 4th clip you'll see is Colonel Simon Blank. And Simon Blank is 30+ year veteran in insurance fraud detection, prevention, and prosecution. He has a team of about 85 investigators, and he'll tell you that's not enough for 21 million people in Florida, but he works hard every day, and he was educating a House Insurance Committee about the day in the life of the leader of the Division of Insurance Forensics and Fraud, or we all know it just as the Division of Insurance Fraud. So you'll see four great leaders: Barry Gilway, Commissioner Altmeyer, Tasha Carter, insurance consumer advocate, and Colonel Simon Blank, a great American who's fighting the fraud fight every single day. So with that, Joe, I'll turn it back over to you or Paul to cue it up. Here we go.
Showing the financials, just the net income slide for the 52 carriers that represent the predominant part of the Florida domestic marketplace. The messages here are really significant in that I'm not sure how these companies are continuing to do business. I've been in the business for 51 years. And I think I can really go through a balance sheet and a financial statement. And I don't understand the mechanics of the business and how these companies can really afford to move forward. What I'm describing here, obviously, is an absolute sea of red ink. And some are worse than others, but there's really only 3 companies in the entire Florida domestic marketplace that have earned a positive net income over the course of that whole 4-year period. The point I'm trying to make here clearly is the consistency of loss across the entire marketplace is absolutely staggering. It's not a decision that 1 or 2 companies are making. The reality is what is occurring in the marketplace is impacting every single company in the market. So some, more drastically than others. I mean, it's not sustainable. It's not acceptable to have Floridians, faced with increasing rates that they're staggering. And now, of course, with the new NFIP 2.0, as you all know, we're going to be faced with the same issue relative to flood insurance. But in terms of overall property insurance, there has to be an answer. Frankly, these companies, you will not have any companies doing business ultimately if the companies didn't raise rates and they consistently incurred these losses. You'd run out of surplus and the companies would have to go out of business. I'll be reporting on 2 or 3 that already have.
How would you rate the health of the Florida marketplace? Would you say it's fair, serious, or critical?
I would say if you view critical as worse than serious, then I would say critical. But if you think serious is worse, then I'd flip-flop that. It's dire. These are not good results. And if Senate Bill 76 doesn't have the impact that we all hope that it will, then these results continue to not be sustainable. We will continue to see companies that either don't survive or decide that Florida is not a place for them to conduct business. We'll see reinsurers that reduce the capacity that they devote to our state, which would be hugely detrimental in a state that experiences catastrophes the way that we do. So these results are dire, and that this is cause for concern. The market conditions now are such that there's no quick fix to this. It's going to be a painful period of time for our marketplace and for our consumers that pay homeowners insurance rates.
We received 1,786 referrals dealing with homeowners. We were able to open 124 cases. We had to close 134. We were able to present 40 cases for prosecution with state attorney's offices. We obtained 32 arrests and 12 or 14 convictions out of those.
Follow up. Well, so we started at 1,700 and we held accountable 14 convictions, and that concerns me a little bit because I know, and we passed some legislation last year, but homeowners insurance, we're struggling.
Yes, sir. Homeowner cases are in particularly kind of hard to work. They're very time consuming. Obviously, in most cases, the homeowner themselves are either involved or somewhat aware of the claims, although that's not always the case. As I've told you before, we're seeing a lot of claims where a third-party contractor, solicitor, law firm will take over the claim and start handling without the homeowner's knowledge. What we usually see is companies that are going out and soliciting homeowners to inspect their roofs, and usually the carrot is, we can give you a free inspection, it won't cost you anything, and chances are that you're entitled to a brand-new roof that the insurance company will pay for. Usually they rely on historical data, or they go to the weather center and look for some kind of rain or significant event that supposedly came through the area. And then they go up and they look for damage. A lot of times the damage that they find is not necessarily caused by a storm or a recent event, but it's just wear and tear of roofs that have been on the houses for a length of time. So we have the solicitation issue, people coming out and trying to get business, and sometimes violating or making offers that are not legitimate. Then we have the contractors to go up. Not too long ago, we had one on a roofer that you might have seen on the news. We were able to arrest a roofer that was actually causing the damage to the home. And the typical scam, right? You had a storm come through your development. We can give you a free assessment or a free inspection. Won't cost you a thing. And if you have any damage, the insurance company will pay for a new roof. They go up on the roof, and instead of just inspecting whether there was actual damage, they created the damage. And they did enough damage to be able to guarantee that they were able to file a claim. So it resulted in a new roof, $19,000. We were able to make an arrest, and from our perspective, we believe that this was a systemic approach by the company, but we were not able to get to that level. We were only able to charge the individual that committed or that did perform the inspection. And so we're very aggressive. We try to do the best we can. There's a lot of challenges dealing with homeowners fraud, not only by the nature of the crime, but also our ability to prove it beyond a reasonable doubt within the court system for convictions. And I think that's one of the reasons that you see the number disparity that you do. The challenges that we have within our division is that it's hard to prove the condition the roof was in before the inspection and before we get involved. And so unless we are able to develop eyewitness testimony or get an engineer or somebody that can reproduce the damage done to the roof and show without a doubt that that was created and it would not have occurred through a natural event, then we're kind of faced with significant challenges for prosecution. Again, what do we need to do? Well, I can tell you that obviously our job is to enforce, and so that is what we concentrate on. I can tell you that what the House and the Senate have been doing, what the legislature has been doing over the last years is precisely what we need, and that is to help us make changes and updates to the statutes that are on the books to keep them up to date and to address the new trends that are being developed or come up as times move on. And also dedicating some resources to be able to tackle those problems, such as what you did last year with the 2 squads for the homeowners fraud, which we just could not, for us to dedicate those resources to the homeowners problem that was so prevalent, we would have had to take them away from other areas in the state. We have 84 detectives doing insurance fraud in the state of Florida, 21 million people. They investigate homeowners, health, licensee. It doesn't take a lot for you to see that we're pretty stretched thin.
I think consumers are on life support right now, to be quite honest with you. They're facing double-digit rate increases. They're paying more money for less coverage. They don't have the option to be able to find competitive insurance companies. They're having to replace entire roofs that may still have a lifespan on them. And so consumers are being significantly impacted at this time. So what we've seen very recently are these fraudulent schemes that really involve mold remediation companies, that involve some potential public adjusters, that also involve attorneys and other industry professionals as well, that are essentially getting together and they are filing claims filing litigation, sometimes without the homeowner even knowing that litigation has been filed, sometimes without the homeowner even knowing that an attorney has been retained. These companies and these professionals are hiring attorneys of their own choosing and essentially taking control over the claim without the homeowner having any knowledge of this. And so when these professionals are perpetrating these types of schemes, really their entire goal is not to put the interests of the policyholder at front, but it's to, it's for their own gain and for their own benefit. And so, of course, in that particular instance, the policyholders are losing out.
And with that, audience, you kind of see the day in the life of, following these very distinguished state leaders, sounding the alarm bell, using terms like dire and unsustainable. And in one of those clips with Commissioner Altmaier, that was Senator Jeff Brandes, who was asking those very pointed questions. And for those of you that do follow the legislative and regulatory happenings, Senator Brandes is leading a lot of those conversations. Senate Banking and Insurance Chairman Jim Boyd is an insurance agent and is also inviting these folks to come to his committee and testify. So, from my perspective, having been in this business over 30 years, if I hear it once, I hear it 100 times. This is the worst I've ever seen it. I had lunch last week in Fort Lauderdale with an agent, 35 years in the business. And I used to believe that folks could get, insurance at any price from particularly the surplus lines market. But he's telling me that even they don't want to do business a lot of times in Florida with some of these really risky properties, et cetera, because we are the highest cat risk in the world. So Joe, I'll turn it back over to you and invite your input as well as others on the panel.
Thanks, Lisa. Yeah, I think what I'd like to do is, again, what we played these clips for is because there has been in place since 2001 a requirement for actuaries to discuss specific particular conditions that might affect the integrity of the balance sheet loss reserves. A couple of things to keep in mind that I think are interesting. I'm going to go through the actuarial opinion to help broadly to put some of this in perspective. I'm not going to go through the entire opinion, but I do want to discern that you can have a favorable opinion, a determination, a reasonable provision, and also have a risk of material adverse deviation. Paul, let's start marching through this. Okay, so the actuarial opinion is a requirement, been in place since 1989. And it is right there, March 1st, with the annual statement for the prior year end. On the next slide, you'll see you're going to have the name of the actuary. You're going to have, are you a consulting actuary? Are you a company actuary? And how you were appointed. And now, of course, more recently, there's been an effort to put how you as an actuary meet the requirements and what information you presented to the board, because the board needs to know that there's a qualified actuary making the opinion. On the next page, again, there are U.S. qualification standards that must be met. On the next page, we'll talk about, and then the actuary can do one of two things. You can either examine what the company did, and you'd say you examined those assumptions and methods, or the actuary will say, I did the work and the company booked my number. So it can be one of two ways that a company meets the requirements. On the next page, we'll see that you also then talk about who gave you the data. I relied upon data prepared by, and you are required to give specific name and title at the company. You looked at it for reasonableness, you balanced it to Schedule P, and you used the tests and assumptions that the actuary considered necessary. You then have, and this is usually this is the bottom of the first page of a 7-page actuarial opinion. The very bottom will usually say, Yes, the amounts carried in Exhibit A, which are from page 3, where the liabilities of the companies are presented, meet the requirements of the insurance laws of the state of domicile. They're computed in accordance with accepted actuarial standards and principles to make a reasonable provision. And there's also a comment on long-term duration contracts, if that's applicable. So basically, on the first page of the opinion, you will see predominantly a determination of reasonable provisions. There's other types of provisions. The reasonable is as good as it gets. I mean, if you see this, this is as good as it gets. You can't get anything higher than this. There's 4 other opinions that you might get. One is the worst kind, deficient provision. The actuary is opining that I did my work and you're not even close. I can't help you. Your reserves are deficient. The other opinions are going to include a qualified opinion, which would mean I looked at it and I found certain reserves seem okay, but other lines of business, I'm not so sure. Or there might be a new line of business. Then you also can get no opinion, which is the actuary is just throwing up his or her hands. And I want to make sure we mention there's also an excessive opinion, which I think the IRS would be interested in, and I think a company should wear as a badge of courage. But beyond these 5 types of opinions, even if you get the best one, the determination of reasonable provision, you're still going to have the relevant comment section. That is an integral part. And you're going to have to talk about company-specific risk factors. And those will be part of the risk of material adverse deviation. And specifically, the risk of material adverse deviation goes on to state that it's a requirement. You are required as the appointed actuary. This is part of your responsibility. And you're opining on the risk that the loss reserves, which are page 3, line 1, and page 3, line 3, the losses on line 1, the loss adjustment expenses on line 3, that those are reasonable. And now the question to you is there anything going on with this company and the markets that it operates in, the jurisdictions, the lines of business, that might make those results on page 3, line 1, and page 3, line 3, might make them become materially adverse? And you, as the actuary, you get to pick the dollar amount. So your standard becomes, I've got page 3, line 3, and line 1. I've got my losses, my loss adjustment expense reserves, and I'm going to pick a dollar amount. 10% of surplus, 5% of reserves, whatever dollar amount you as the actuary choose. You choose the dollar amount, you tell the regulators why. And then the question to you is, could those reserves be worse than the carried reserves by the dollar amount that you picked? And your answer is going to be yes, it will, or no, it won't. And here's my reasons why it will. Here's my reasons why it won't. And what we have heard from the videos is 4 distinguished professionals in the insurance marketplace in Florida talking about the conditions on the ground. And I think Commissioner Altmeyer used the term dire. Barry Gilway, I think, used some other terms about, red ink for 5 years. And so what we need to do, and we begin to do it on the next slide, you'll see this report. And this is a segment of the actuarial opinion. Every company has to do it, every P&C company. And it talks about the first 4 lines of that report: unpaid losses, unpaid loss adjustment expenses, they're gross and they're net. Lines 1 and 2 are net, lines 3 and 4 are gross. So it's before and after reinsurance. And there's no way around this. This is what you have to discuss. All 4 categories: direct losses, direct loss adjustment expenses, net losses, net loss adjustment expenses. And you heard Barry Gilway talk about reinsurers are concerned. And the reinsurers are certainly concerned because they are the ones creating the capacity by having ceded losses set to them. On the next page, here's where that materiality standard will appear. It's a dollar amount. It's every company's got it right there. And it will be 10 million, 50 million, 25 million. It will be reduced to dollars here. And then the question is pretty straightforward. Are there significant risks that result in material adverse deviation? And it's yes or no. There's no gray area. You say yes or you say no. It's summarized right here. One of the things that's interesting to me is that I believe countrywide, the estimate is in the neighborhood of 35% of the opinions countrywide have a risk of material adverse deviation as yes. The other 65% have a risk of material adverse deviation says no. So it's about 1/3, 2/3. In Florida, it's not much different than that. It might be 40, 45%, but it's more than half of the companies in Florida where we've reviewed the public information, that is their statements of actuarial opinion, whether they're Demotech rated companies or not Demotech rated companies. It is about a coin toss as to whether or not there is a risk of material adverse deviation. And given the comments of the four Florida-focused professionals at the beginning of this, that strikes me as interesting. Again, this is a NAIC requirement. You can see for yourself the 5th item down on that list is the materiality standard. The 6th item down the list is the risk of material adverse deviation. You have to do this. It's a national requirement and everybody has to do it. Okay, and so you need to describe the major factors or conditions, the dollar amount that you chose as your materiality standard, and then you have to make an explicit statement, and it's yes or no. And I think, with Florida, the industry, the four folks at the beginning that gave the presentation, the industry in general, and I think to the next slide, Paul, and thank you. I think that these are excerpts of a letter that was sent. I think that's the handout number 1, the Altmaier letter to Ngojlia. And it talks about some of the things that are adversely impacting Florida. And even though it's about 8% of the homeowners' claims, it's almost 80% of the homeowners' litigation. And I'd like to start now to transition this over to Guy Fraker, who's done a number of studies, most of them recently on Florida, but he's done many other studies on other aspects of regulatory and legislative and judicial changes. So Paul, if you could get us to the slides for Guy. We'll come back to this one. It's another handout. Guy, all yours, sir.
Thank you, Joe. And let me first start out by saying how much I appreciate the opportunity to contribute to this information and the webinar. For most of my career, I found myself working with actuaries as the real cornerstone and fuel for the industry. What I'm going to do is challenge your thinking a little bit by building on the comments that were made by these top professionals and provide some concrete examples of things that are going on in the marketplace that essentially blow up severity and frequency in terms of their predictability. The uncertainty in litigation has resulted in several organizations around the world identifying Florida as the highest risk market in the world, and not because of hurricanes. So I'm going to back all the way up for just a moment. Bear with me. insurance essentially, as an industry, fulfills a couple of missions. You can go all the way back to the colonial period and Ben Franklin launching the first homeowners company, or the massive sea change of automobiles going viral, which would not have occurred had it not been for Mavericks creating auto insurance companies and consumer credit, obviously going hand in hand. So the missions of insurance are to protect consumers and their assets from sudden accidental large losses. And that in turn creates economic stability and growth, both for the consumer and for the economy, because it enables consumer spending. Without that protection, consumers would hoard cash and in turn not be able to collateralize consumer credit. Second, and I gained real clarity around this during the 3 years I worked with the US government on pandemic protocols back in 2003 through 6, when they identified the insurance industry as absolute essential infrastructure on par with national defense firms and utilities, because the other part of the insurance mission is to organize massive cash flow by collecting millions of small payments, organizing that capital, and then pushing between 90 and 110%, so the combined ratio, pushing 90 to 110% of that cash back out into the economy in the form of jobs, claim payments, real estate purchases, taxes, etc. Within that mission, the cornerstone, of course, is the actuarial capabilities of reliance upon a limited number of causal losses that are, by definition, grossly oversimplified, I admit, but random. And that's a key element to understanding what's going on here. Losses are sudden and accidental, and they're caused by a quantifiable list of events. The consumers, with the services that they receive, translate into insurance, must be available, provide adequate coverage to the consumer's needs, must be affordable to acquire, and must be reliable. In other words, the insurance company must be financially viable to keep the promise. So if we go through this list very briefly, our loss events, if we look at the claim litigation and the staggering separation making Florida unique, we have, this is a map provided by an NAIC, National Association of Insurance Commissioners, map about claims versus claims litigation. And what I want to try to help people get their arms around is what Florida's litigation means. So on any given year, in 49 other states, consumers on average will file 492 lawsuits. This year, after the third year of 27% compounding growth, Florida courts alone, one state, will receive 95,000 lawsuits. Now, I will say what many people wish wasn't going to be articulated. How do you get to 95,000 lawsuits, claim disputes, because you have to have a claim to have a claim dispute, compared to 49 states that operate with 492? And the answer is you manufacture the claims at will. In my original study, I had confirmation from multiple reinsurers, regulators out of state, members of the US Treasury, all consensus that reliable sense of loss severity and loss frequency no longer applied within the state of Florida. So before going any further, I'm going to make an assertion that I'm also repeating in a report that's going to be released, the third report recently, or in the near future. Florida's residential property and casualty market has ceased to exist. It has been replaced by an artificial litigation market so widespread that it is generating approximately $4.5 billion in annual revenue to this very sophisticated and brilliant and innovative network who drive the litigation market. Let's put Florida's litigation in a different perspective. The chart you're looking at is the year of 2020. The blue spikes are the number of lawsuits filed that day. The green line across the middle represents the annual average from 49 states, each of 49 states. So all of those blue lines and spikes above that line represent days where more lawsuits were filed in 24 hours than in the other states over a year. June 24th, 2020 stood out for me because 1,139 claim disputes were filed in the courts. Now, had there been a hurricane, okay, maybe that's understandable. But in 2020, there were no landfall events. Now, detractors will say, we've had so many hurricanes. That is a nice distraction strategy. On every day in this graph, I mapped out the NOAA weather data, and I'm telling you, there wasn't any. So this puts into perspective why I make the statement, it's no longer an insurance market, it's a litigation market. Now I want to briefly go through a tactical case study that is now affecting as many as 12 carriers in the state of Florida. The graph on the lower left represents 3 years of lawsuits filed against American Capital Assurance. For those who, for whatever reason, may not know, American Capital went into receivership. What is interesting about this is the second year, the blue stacks, 2 founding managing partners of plaintiff firms reached out to the general counsel and CEO at American Capital and said, we've calculated your premium, we've calculated your surplus, you're going to be out of business in 12 months, you just don't know it yet. AMCAP had been targeted for a complete harvesting of capital. Does that sound like random, sudden, accidental losses? Going back to 2018, and this is essential to understand what Florida carriers are up against. You see the lawsuits are very few, and then they start to ramp up. Think of that as beta testing. So they're testing a plaintiff strategy, they're testing the reaction of the insurer, and the insurer and the defense firm did exactly what any insurance company would do. They invoked their policy language and they fought the claims. So what happened? The graph on the right is the history of one of 387 claims, lawsuits that took place, that occurred over less than 9 months. The key to the plaintiff strategy is once they find a lawsuit model that will generate capital, generate revenue into the litigation economy, they will move so fast that form filings cannot possibly be made and approved to stop the bleeding. So briefly, follow me through this, because I believe this is a great case study in the challenge, and my heart goes out to you, the challenge actuaries face. Moving from left to right, in January of 2018, two lawsuits were filed, or two claims were filed. The properties were inspected. The claims were closed by the policyholder for no damage. 18 months to 2 years later, AMCAP receives a supplemental claim, which brings different sets of requirements, correct? They bring a second claim for 85% of the total insured value. Now, forgive me for being blunt, but if I get a claim for 85% of total policy value, I should go to that property and see what? Bulldozers and rubble. Well, in the time in between the two claims, units sold at asking price, units sold at asking price with no disclosure of damage. Not one occupant of the condo association had filed a lawsuit for water damage. And in depositions, which I have, we found a property manager who finally admitted he had over 100 condo associations. He was bringing in his own roofer. They were discovering a new type of damage called wind lift, and that required replacement of the roof. Now, I can talk more about that in a minute. But the key here is claims closed by policyholders for no damage. Time passes. Now you've got a $12 million supplemental claim. What happens to that? It goes to appraisal and alternative dispute resolution with an umpire. The appraisers come in, the umpire says, wait a minute, you're at 0. And over here, you're at 12 million. I privately think you've both been drinking. So boom, we're going to split this down the middle, 6 million. Times 387 suits. By the end of 2020, the prophetic statement made by the two plaintiff attorneys a year earlier had come to pass. AMCAP was in receivership. And here's where it gets even more interesting. Of the 1,715 policies that would have gone into receivership, 1,690 policies were picked up in the marketplace before going through the clearinghouse. Now, when this litigation market identifies, targets an insurer, finds a vulnerability, institutes a rapid, repetitive lawsuit strategy that continues to gain traction, guess what happens to the companies who inherit the balance of the book of business? I'll give you a hint. It's called a virus. That virus, that litigation model, spreads. So right now, under Senate Bill 76, we have the pre-suit notification, the intent to litigate. Interestingly, look at this bigger graph on the pre-suit notification cases that are calling for the most damages. Condo, condo, condo. Large residential development, property manager for condo, homeowners association, condo association. Guess where those policies came from? AMCAP. Now, who are the attorneys that have picked up those policies and continuing the practice until it runs out. And as an aside, for those of you who have, read prior studies or been looking at this for some time, ask yourself at the end of 2020 and into 2021, how much discussion has there been about enhanced fees, the fee multiplier? And the response is almost none, very little. They understood that that was a message point that wasn't going to sell. Well, it wasn't a lot of income, but when they won, those were pretty substantial. I submit to you, the condo association suits and this litigation model provided the replacement income. So before I hand this off to the extraordinarily capable hands of my colleague Wesley Todd, I want to recap. Do policyholders have availability to adequate coverage? No, and it's diminishing. Are the premium dollars being funneled back into the economy? No. $4 billion a year is being redistributed from policyholders' pockets to a litigation syndicate. Are the coverages reliable? No. In David Altmaier's testimony, he identified 12 carriers who are on a monthly reporting system as a regulatory warning track, and all 4 experts testified that it's not viable anymore. And so my overall conclusion is that this is a litigation market, not an insurance market. And I want to close with this thought. All I'm suggesting that is tactical for your benefit. What I'm suggesting is, rather than just dismiss this notion as a stretch to make a point, this is something I internalize and believe. And I say that having worked in insurance markets that weren't relevant yet, where less than 2% of all households had one product. I understand the importance of this mission, having worked in South Africa, having worked in West Africa, having worked in Canada, having done remote advising in Seoul, Korea. I've never seen anything like this. All of the professionals who rendered opinions in those videos did end their presentations with requests for legislative assistance. Florida's current legislative leadership has decided that there shall be no reforms until after the 2022 elections. And I'm not blaming them for woes. What I'm saying, if you could see me on my knees, you'd get a laugh. Insurance teams, the executives, there's no harm in taking 1 or 2 days, sitting down with your executive teams and saying, what if Guy's right? It is actually very empowering, because some companies are having tremendous success fending this litigation market off by rethinking the market that they're in and not continuing to try to manage it as business as usual. So for my declaration that the market ceased to exist and has been replaced by this economic wrecking ball that's only going to get worse, my most important message is carriers can take action by thinking about this differently, using a different set of tools, and absolutely finding the opportunities to bring a greater degree of stability, success, and in the process, look out for their workforce, their investors, themselves, and their policyholders. There is light in here. So with that, I will turn it over to Wesley.
Wes, this is Joe. I'm going to jump in for a second. Wes, you've been involved on the defense side of issues for your entire working career and, founding Case Glide. And I think just to set this up, we heard what Guy said. He's done several studies. We heard what Commissioner Altmeyer and Barry Gilway and Tasha Carter and Simon Blank said. The actuaries are charged with looking at major factors, combinations of factors, particular conditions, not so much at the marketplace level, but at the company level. So I think that this is where we're transitioning and where you're going to tell us a little bit about the macro level, but you'll get into what the companies can do. So please talk about that, if you will.
Yeah, thank you so much, Joe. And thank you to the audience for taking this deep dive. I really like the angle that Joe's bringing here, because I think that it's a really important perspective. So I have two categories of observations to bring to the table today. One will be just an objective review of the litigation statistics against the top 20 or so insurers in Florida domestics over the past 4 years. And we'll actually race through that because it's a really easy picture to describe in graphs. And drawing any conclusions on that will be outside of the scope of this. That's a whole separate webinar, but we'll just update everybody on where we're at as a market with those statistics. And then we're also going to talk about, okay, well, if we can get data and we can have a better understanding of where we stand and really understand the risk of material deviation, what can we do with that information, or what can we do with those tools? So we're walking through some actionable insight around what are the more advanced insurers that have had success mitigating the risk of litigation in Florida. What are they doing differently in a variety of different ways, but what are those common elements that we see? So starting with the litigation data, draw your attention to the left column where you see the 1,000 to 6,000. So as you can see here, 2018 and 2019 more or less look relatively steady, except you see if you go over to the right column, or excuse me, the right graph for 2019, you look at May through July, you see this spike. And that coincides with the AOB reform that was in place. So look at those numbers though. You see some threes, you see some fours. That means 3,000 or 4,000 lawsuits versus these top 20 insurers on homeowners, residential, within that given month. And you can just see here that there's pretty steady in 18 and 19 with a short spike around the AOB reform. So that's an observation, and it's really relevant to the next slide, Paul. So then you look at 2020 and 2021, and you see the same left column for 2020, but then we had to actually extend the column for 2021 to reach up to the 6,000 to 7,000 number for lawsuits against Florida insurers within a given month. So what do we see here? We see that things remained relatively steady in the beginning of 2020 in the 3,000, 4,000 range. But you can see the steady climb starting in June 20 and then peaking in July of 21, just several months ago. And this, eventually, you can look at as after the fact, this race to the courthouse, the spike that persisted for approximately 1 year, this increasing spike. And the graphs tell the story. So, if you kind of compare that to 18 and 19, you see there looks to be some impact of reform before and after, right? You see spikes before and then you see drop-offs after. And, I'm not here to reach those conclusions. Our focus is really on capturing the data and letting the professionals take action on it, and then make it cost a lot less, make each of these cases cost a lot less. But, we are happy to dive into a separate discussion on some of the different opinions around this recent behavior. I mean, it's obvious when you look now at those last 3 months, you see the significant drop-off. There are folks saying that is actually not a drop-off, that there are notices of intent that are lining up that will add to the litigation total. And there are arguments for and against that. There are also, arguments saying that this is just a return to those numbers from, that were outside of the spike. So there's opinions on both sides. We don't, we like to get enough data to really be helpful to the customers and not really jump to any conclusions at this early stage. But, for those folks that are trying to sift through those cases, I'm sure they'll tell you that they feel like this is some good news, even if it's just a return to normalcy that may have actually been caused, as one opinion might state, by the reform itself. So moving on to the next slide. This is going towards the comments of, okay, well, if we start to get more clear about what that risk of material deviation is, and we start to understand and look back at the data, well, which companies out there, what does a company look like that has a good grasp of that? And what we see is that there's Florida insurers that pay less on these lawsuits and they know more, right? So then it doesn't mean that they have less of a risk or more of a risk. They just know more about the risk because they have better data. And there's two elements to this. One is that these companies, first of all, get a thermometer, if you will. They're able to take the temperature of what's going on in their cases because they have insights into the data. They know what's actually going on. They're tracking types of cases. Plaintiffs' attorneys are tracking the demands that are out there. They've been doing this for years, actually. So they have the thermometer, so they have a general idea of what's going on. And then over the past couple of years, they've really evolved to having a thermostat, trying to change that temperature, trying to lower the frequency. So if you call that Florida Claims Litigation 2.0, there's a few elements to it that we see across Florida carriers. These successful carriers have actionable dashboards. So there's a lot of data here, as Guy pointed out, and as you just saw, it's not really possible for any individual to comprehend what's going on without seeing the trend line, seeing the year over year, seeing the month over month, breaking it down by different categories. So these companies are looking at the actionable dashboards, which we'll go into a little bit more detail in the next slide. They're making better decisions on attorney selection, and they're segmenting these cases, right, to properly calibrate what is a win and what is not. So real quick, just go through these elements for those folks that are, I think this was targeted to actuaries, which is fantastic. What is a litigation department? What should it look like? It's folks that are measuring wins, right? They're focused on savings. They're not really focused so much on expense. That's a much smaller number than the settlement amount. They're focused on how much are we settling these cases for? Are we doing better or worse than last year? Are we doing better or worse than our peers, right? Moving on to the next slide. What most of these companies have found is that their best lever for doing this is through attorney selection. So this right here is just a mock screen of the type, the concept of decision making around how do I pick the right attorney that's going to take a demand of $10 and settle it for $3, right? And how can I track that not just to the firm but to the attorney? How many cases is that attorney able to close for me as well? So I can get as clear statistics as I can, really lower my risk. And are there attorneys that we're not using? There's a handful of attorneys in Florida, if you're not aware. Are there attorneys that are not on this individual insurers panel that they should be using? So these are the questions that you would ask with advanced attorney selection. Number one lever to having a really nice looking dashboard that's saving money. And one of the more advanced things that we've seen now for probably 6 years is the ability to segment cases, right? So the ability to say, this is an IRMA case, this is a cast iron pipes case, this is a CAT case, this is a tri-county case. You have to have apples to apples comparisons, and you have to be able to lump these buckets together. A, to have a proper understanding of your risk of material deviation, but B, to actually make an impact on it, to set the benchmark for what is a good settlement in an IRMA case, and let your team know that. So the bucketing of cases does a couple of things. One is it allows you to run good analytics, but two is it also allows you to have particular strategies. So some of these cases might be trial cases. Some of these cases might be spend as little as possible and get them settled. Managing that by trusting an adjuster to send an email when they've been as busy as they've been it has been a recipe for disaster. Having set up predefined workflows based on the type of case, based on legal strategy, is really the advanced form, the claims litigation 2.0 that we're seeing, and it's providing all of those benefits that we just talked about. So, you know, to Guy's point, the plaintiff's bar is obviously armed with these tools as well, right? Top Florida carriers are armed with these tools. If you're operating without tools like this or strategies like this, you know, you're going to have a much more difficult time. One more point that I would add, you know, before I close, is that we're at this unique point in time where SB 76 has now offered us up a standard data set. So for years, it was only CaseGlide's clients that could produce any data, what was going on in their litigation, whether it be a data call or you know, something from the state or something internal. And now everybody is required to have a real clear breakdown of what type of cases do I have, what are they asking me for, what am I paying and when, and who's involved, right? So now everybody. So we view this as really this golden opportunity for the industry to come together, better understand what's going on with their peers, you know, leverage the value of these tens of thousands or hundreds of thousands of cases experience, and be able to better dictate how to save really large sums of money in each individual company. So we're at a real tipping point here where companies, if you are an actuary, you know, have a real good opportunity to take advantage of the data that's going to be available via the data call, and we're hoping to play a significant role in that as well. So to conclude, you know, these tools are all about taking, you know, providing you information, the smartest folks in the room with information, letting you turn those into intelligence. You know, they're going to better inform you about the risk of material deviation, because you're going to actually have a real good understanding about what is the specific liability of these cases that you have on your books, and then help you move the needle going forward to lower those costs. So again, I really appreciate the time. What a great group of speakers thus far, and thanks for being able to be a part of it. Hopefully this was helpful.
But you're not off the hook yet, Wes. I got a question for you. I think so. I think it's been in a catastrophe-prone area. It's been very often we at Demotech will ask for a company's disaster recovery plan. We always ask for their catastrophe response plan. Want to see it? When's the last time you practiced it? And I think what I've heard between the videos we played and Guy's comments and even your own, I'm thinking that we should add a litigation management plan to that. So it's not just disaster recovery and cat response. I mean, what would be your thoughts on the major bullets in a litigation response plan or litigation management plan?
I think it's those three components, Joe. I think it is, do you know what's going on? Do you have granular data on what's on, you know, do you have this case segmentation? And then do you have the right attorneys and the right tools in place for your team to be successful? And you know, the insurtechs are coming to play with this first, right? These companies that are moving into Florida tech oriented, this is the first thing they're doing. They're saying, we're going to make litigation an advantage, not a problem, right? Citizens as well has invested hundreds of millions of dollars in their litigation management program, and they generally do have better outcomes than many of their peers. So there are benchmarks out there, Joe. And then there's, of course, a great deal of private carriers, dozens that we work with, that have given us all the best ideas for the past 5 years about what are the essential elements. And so I'm really just reflecting those here for the broader audience.
Well, but let me ask you this. You've been involved in defense work either at the company level, and here you have, you know, the clients you've had over how many years since you founded CaseGlide?
Since 2015.
All right, so for the last 7 years. So let me ask you this. How many times in your career, either as an owner of CaseGlide or as a defense attorney, has an actuary contacted you and said, I'm interested in finding out some of the particular problems that there might be for this company? How many times have you had to answer that question?
It's certainly less than a handful of times, though. You know, as we talked about before, we do produce a steady stream of data that a lot of powers that be take access to and use and manipulate within the organizations for our clients. So I don't know that that's the only amount of actuaries that have looked at it, but those are the only ones that thought that they needed any of my help personally.
So your clients could have the segmentation and they might be passing that on to the actuaries without you knowing it.
Yeah. But personally, just less than a handful.
Yeah, I think.
Joe, this is Guy.
Yeah.
I want to reinforce a very important point that Wesley's brought up. One of the big strategic advantages for the plaintiff side of this is an incredibly efficient and innovative way of sharing results and gathering shared data. In the insurance industry for years, I was the original architect for AM Best's innovation scoring system for insurers. The insurance industry has always been plagued by self-isolation. Now, it could be antitrust scares people away from sharing best practices. It could be a sense of competition, but this is a market hinging on viability. And one of the invaluable services that Case Glide and Wesley are offering here from a trusted organization that is not serving competing interests, is dedicated, is the ability to aggregate and share important information so that insurers could possibly discover they're about to be targeted before it happens. And also to be able to look at policies before jumping into the clearinghouse or moving policies out of companies that have gone into receivership. This is exactly the kind of strategic tool and capabilities from a trusted partner that really could be a make or break in terms of viability, I think, for many of the insurers in Florida.
I'll just real quick. Yeah, I mean, we don't come up with these ideas. We get all the ideas coming to us. And so, for example, like we want to really support OIR's effort here in getting this data and getting the most out of it. So we're doing our best to work with them and help support them. And a lot of our clients and folks come to us with really good ideas about how to make the most of this. So this is really just an assembly of ideas from the group, and we're fortunate enough to be in that place to get those ideas from people like you. So, we're really just getting started, to be honest.
Lisa Miller, did you have a thought? And then I'm going to wrap up.
I did. I wanted to correct one thing that Guy Fraker mentioned. Guy, where you're saying that the legislature is saying no way, no how, we're not going to make changes. It changes daily, Guy. That was probably last week, what you heard at the Florida Chamber Summit. There's very little appetite to do anything. But this week, there's been some movement. So call me the eternal optimist, and I never give up. But for those of you on this call, I think, as Joe said, we're going to wrap it up. But let me leave you with this. Every day is a new day in this process. Every day is a new day for a claims executive that will get anywhere between 10 and 50 lawsuits in their inbox. Every day is a new day in this fight, and it is a fight, but it is a noble one. We are doing this on behalf of the good consumers in the state of Florida. We have 7.5 million property insurance policies in this state, and those of us in the trenches every day, actuaries, claims personnel, underwriters, insurance agents, C-suite employees, rating agencies, consultants like me. It is a privilege to serve in this market, and we will do everything we can to convince the legislature that more reform is needed. I'll leave it at that.
I really appreciate you bringing that up, because obviously my deep dive that started 18 months ago has been on behalf of, I would hesitate to say maverick, but very strong and forward-thinking legislators. All we have is unfortunately a track record of reforms being instituted and a 27% growth in litigation on the topic that was reformed. And that's happened 3 years in a row. So what I am suggesting is that something is going to have to happen. We now are in a place that Florida, I don't believe, has ever been in before, and certainly no other state finds themselves in. We now have pockets where Florida consumers cannot acquire homeowners insurance from any carrier at any price. And that's a quote from the commissioner as well as Barry Gilway. Their growth is so fast, they're having to withdraw and restrict. So in terms of economic stability and in terms of legislative action, there is a pace issue here and a targeted, appropriate subject matter for reform that is going to just have to the pace has got to get picked up and the focus has got to come. Because right now we have people who want to move into Florida who have to accept forced mortgage coverage.
Well, and Guy, there's one more thought. You know, a lot of this, probably 65% is roof claims, and then you've got the water claims. And, you know, a lot of other states, except Florida, they have the flexibility to let consumers, you know, have an actual cash value roof or a replacement cost roof, or, you know, in this state, we could have a dwelling policy a lot of times, and we don't need to get in the technicalities. But there's, you know, we just need more options in Florida when it comes to roofs, and we can debate that all day. And we need options when it comes to the Hurricane Catastrophe Fund and make some changes to that. Some people vehemently oppose that. So I'm the eternal optimist, and I'm going to believe that when session convenes on January 11th, 2022, for the next 60 days, we're going to fight the good fight, educate legislators. I believe we can, and hope for the best on March 11th, 9th, whatever the exact date is that it ends, and see where we are. So I think that's a good close for you, Joe.
Thank you. I think I'll close with the comment. I think on the risk material adverse deviation, clearly, it strikes me that the state of Florida should be appreciably higher percentage than the national average. And I will say this, something I've said, you know, Florida may be a geographic peninsula, but it is a island when it comes to claims procedures and practices. And I'll end on this too, again, because I think it impacts the risk material adverse deviation to the extent that the residual market in Florida is looking for ways to depopulate itself rather than have the conditions that generated the need for a residual market addressed in the legislature or through other means is, I think, another indication of the challenges that Florida faces. We appreciate everyone. I want to thank Lisa Miller and Guy Fraker and Paul Osborne and Wes Todd for joining me and doing this. And we thank you so much for the time and effort. Thank you.